have any fear about going around town in different places and?
No, not really. I mean, no matter where I go, it's gonna be the same. You know, when I come out here, it's the same. You know. No.
What about the neighborhood where you lived? Did you all feel safe there?
Oh, yeah, it's our neighborhood. Yeah,
Oh, I mean, you can live in a good one and you live in a bad one.
I mean, I'm a man, so wherever I go, I'm gonna be a man. So when you say feeling safer or whatever, I'm gonna be safe wherever I go because I'm gonna take care of myself. Because I mean, that's where I'm built.
Look, I'll be honest with you. I'm not sure I have the same level of confidence about going just anywhere.
Yeah.
Did you, when you were growing up there, did you feel like you were responsible for taking care of yourself and you needed to know how to defend yourself?
Oh, yeah, definitely.
How about Mr. Hunter? Was he the same way?
Yeah, everybody's the same. You know, I mean, we grew up where it's stuff everywhere. So, I mean, that was life. Just.
Well, that's what I'm trying to.
I can't explain it, but.
That's what I'm trying to find out, right?
Yeah,
I mean, what was life like in your neighborhood? Was it?
To me, it was normal.
Yeah.
So
well,
when you say what was life like, it was everything in life is normal. I mean,
sure.
If you there in it or wherever you are, it's the time you in.
Were you aware of like violence in the neighborhood? People getting shot, or?
I mean, to me, that's everywhere. Yeah. I mean, it wasn't.
It's not, as it turns out, but.
Yeah. To me, I mean.
Yeah.
Life is like, yeah, people got shot. I mean, if I come out here, somebody got shot. So, yeah. I mean,
were you yourself ever the victim of violence?
Yes, I was.
What was that about?
They was trying to shoot somebody I knew, and I was there. You know, yeah, I was a victim of violence.
You got shot?
I got shot. I've been shot. 89.
Let me ask you a question while we're at this. Have you yourself ever been convicted of a felony?
No.
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 You know, your mom, I noticed that when she was sworn, she did not swear. She affirmed.
No.
Is that because of your parents' religious beliefs?
Yeah.
Were they particularly conservative Christian?
Yeah. There's Christians. Yeah.
And so, were you raised in a household where alcohol was forbidden? Let's say.
Yeah. Smoking, all that.
Smoke, none of that.
None of that.
So you never picked up any of those vices?
No, I didn't see no reason to.
And I can understand that. But it doesn't stop us from doing it sometimes.
Yeah,
so you never drank alcohol. You never drank.
I can't say I never drank alcohol. Now I'm grown, but
sure.
Growing up, definitely no. I was raised no smoking, no drinking. Yeah. So I'm grown. Yeah, I had a drink now.
No drugs.
I'm grown. No drugs. Definitely
Right.
no drugs.
How
I
about-
didn't see needing drugs.
Yeah. How about Demorris? What do you know about his household? The household that he grew up in?
I mean, from what I've seen.
Well, yeah, of course, from what you've seen.
Yeah, whatever I've seen. Yeah. His mom was like my mom. You know, we was kids, so and we was raised to respect elders. So it was different times. I mean, his dad, like we was kids, we didn't have the right to be like grown folks. Now the kids today,
Sure.
we had to abide by rules. You know what I mean? And respect each other's house. So his mom was beautiful. His dad was cool with me. His mom sent me to the store. You know, like out of all the kids, she said, "You go to the store for me, Sharon." You know, I had to go get the cornbread or whatever. You know, just normal stuff. So.
Well, I guess what I was asking was, did he grow up in a household where, alcohol and tobacco and that sort of thing was forbidden, as far as you know?
I mean, I can't really say what was in his house, but I never seen his mom smoke. I never seen his dad really just drink or anything. In my memory, I can't really say his dad was drink or smoke. So.
Okay. So while the two of you were growing up, would you say that you were good friends?
Yeah, I'm sorry.
And did you at that time know Demorris to be, violent or dangerous or a person who sought out conflict?
No, never. Demorris never go looking for trouble. I can tell you that personally. Never. Now, if you bother me, yeah, we're going to defend ourselves. That's how we do it.
That's how you both were raised?
Yeah, in our neighborhood, we don't go looking for trouble, but, people in the neighborhood, if they bother you, you're going to protect yourself. I'll say that.
Right. Now, both of your parents talked about Demorris coming over their house.
Right.
Was that a pretty regular thing?
Yeah, he's from the neighborhood, he came to the house, he's like family, so yeah.
Well, both your parents said that at some point he started referring to your parents as mom and
my
pop.
mom just like, I love my mom. My mom loved him just like, my mom and dad loved him like a brother, he's like a brother, you know what I mean? So, respectful, because if he wasn't respectful, he wouldn't come to my mom's house, period.
Yeah, that came across from your dad.
Yeah, and my dad didn't play.
Your dad?
And my dad liked straight shooting, and D was a straight shooter. So that's, as far as I'm concerned, that's what it is.
Your dad comes across as somebody who doesn't take any mess from anybody.
He don't.
Right.
He raised us, and I respect that.
Now, at some point, you know that Mr. Hunter ended up getting in trouble with the law and going to prison.
Right.
And you would have been, what, maybe 17 years old when that happened?
Yeah, I was 17.
Do you remember this happening?
I don't remember it happening, but I did hear about it. I never really got to the bottom of what he went to prison for because he was a teenager now. He was doing his thing or whatever, and I was going to school, whatever. You get older, you start.
Sure.
But we was friends. We was always friends, though. Yeah. I don't know exactly what happened, but I knew something happened.
Is it fair to say that by this time, and where I guess we're talking about the early 80s or so,
right.
That drugs were in your neighborhood and it was becoming more violent?
Yeah.
And you had to be vigilant to take care of yourself and defend yourself?
That's from ground up, from kindergarten, to right now. So, yeah,
sure.
I would say that.
So he was out of your life for a number of years.
When he went to jail, yeah.
Do you remember how long it was?
Probably 15, something like that. 15 years.
Did
But we always stay in contact.
You stayed in contact with him when he was locked up?
Yeah, always. To this day, always.
And did you see him when he got out?
Yeah, what's that?
What was the first time you saw him after he was released?
I picked him up when he got released.
You picked him up from prison?
I picked him up from prison. Yeah. And took him to his grandmother. And his dad was there. His dad didn't even know he was released. He was shocked. His dad answered the door. And matter of fact, he was like, "Dad, yeah, so yeah."
He would have been in his 30s by then?
Yeah, I said we was 30s. I had a family by then, so yeah.
You had already got married, started having children?
Kids, yeah.
Tell me a little bit about that. Like, how long have you been married?
36 years.
You got a long ways to go to beat your folks.
Yeah.
And how many kids?
I got 2 kids, 3 foster kids.
Really? I don't think you'd ever told me that.
Yeah.
3, okay. When Mr. Hunter got out of prison and you went and picked him up, took him to his folks' house, did he go to visit your folks at any time?
Yeah. We visit his folks. We visit my parents. You know what I mean? Yeah.
And did your parents change anything about the way that they treated him?
No, he family to us. So he came in, everybody greeted him like,
Was anybody, anybody hesitant about bringing someone who had gone to prison for violent crimes?
No, they don't even see
in their midst?
Yeah, no. Even my kids, to this day, they don't see me like that. You know what I mean?
Right.
Yeah.
You saw a different side of him?
Yeah, different side. From what they say of him and what I know of him, it's like 2 different people.
Now, at some point, he moved away from Oakland, California?
When you say some point,
Well, I don't want to put words in your mouth in terms of what years that would have happened, but I'm saying at some point after he got back from prison, and now obviously
Yeah.
he moved away from
Yeah.
Oakland, California. Did you still keep in contact with him then?
yeah, pretty much.
Were you living in Oakland still, or did you at some point move away from Oakland?
I moved away from Oakland.
Where'd you move to?
First I moved to Concord, then I moved to India.
First you moved to?
Yeah, first, when I left Oakland, I moved to Concord. And then,
Could you spell that for the court reporter?
Concord, C-O-N-D-E-R.
Condor.
Concord.
Condor, okay, I'm sorry. I've never heard that one before.
Yeah.
You moved to Condor, and then you moved to
Then I moved to Pittsburgh, I bought a house in Pittsburgh, then
Pittsburgh? Pittsburgh, California?
Pittsburgh, California.
Never heard of that either.
All right.
Okay.
Then from there, I bought a house in Pittsburgh for my family. Then I bought a house in India.
In Antioch?
Yeah, India.
Like from the Old Testament?
Yeah,
Okay, and that's where you live now?
that's what I live in.
And that's in California too?
That's all in California.
Obviously, you know about why we're here
Yeah,
and the charges that have been leveled against Mr. Hunter and the conviction that he stands under right now, which is why we asked you to come today and did you ever change your mind about the kind of man that you perceive Mr. Hunter to be?
I mean, it's hard to say because I never seen what y'all saying about it. You know what I mean?
Right.
And what I read is, you know, it's kind of hard because he's my friend, you know what I mean? So who would, I'm a real friend, you know what I mean? I can't judge him off what he did. I wasn't there for one, so I don't even know if he did or not, so he's still my friend regardless, you know? So, yeah, it's hard.
Do you continue to love him as a brother?
Yeah,
And that's why you made this trip
right,
out here,
right.
to let the jury know?
I mean, how can that'd be like being a fake friend, you know what I mean? Like everybody, I mean, life, we all go through something, you know what I mean? So, to me, he's my friend, so, bad or little bad, I mean, I can't judge him, I'm not God or nothing, so, that's
In
where I'm
terms
at.
of-
I mean, I feel, you know, from what's going on, whatever, I feel sad for everybody. I think it's all a loss on both sides, you know what I mean? So that's really how I feel, you know what I mean?
Well, you know, sometimes we hear about things that people have done,
Right.
and we personally feel betrayed,
Right.
or we feel like they've not been honest with us,
Yeah.
or did you ever?
Your Honor, can we approach?
Like I was saying, sometimes, you know, things happen and we end up changing our mind about what we thought about a person.
Right.
Has that happened to you about Mr. Hunter?
No.
You still think he's the same person you've always known?
I mean, he always been straight with me, you know what I mean? Like,
Was he always reliable with you?
always.
Was always somebody
So
that,
that's, yeah,
that
that counts a
you-
lot, yeah,
that you could count on?
yeah.
Like if you had ever, been threatened or felt that you needed help, was he somebody that you could rely on to do that for you?
I mean, I never relied on anybody if I've been threatened. I'm a man's man, you know what I mean? I mean, me and him always been straight up for, you know what I mean? We got a connection there. He's a real dude, I'm a real dude, you know what I mean? So,
Yes, sir.
I mean, situation is bad now, but he's been good to me, and I've been good to him, so, I mean, there's nothing I can say that, yeah,
Sure.
I mean, the situation is bad, so you got to, balance that, but, I mean, that's as far as I can express myself now.
That's fine. That's fine. Thank you very much, Mr. Alexander. I have no further questions on this witness.
Thank you. Cross-examination.
We have no questions for this witness. Mr. Alexander, thank you for coming, sir.
Thank you, sir. You are free to go. Defense, you may call your next witness.
You are called Demorris Hunter.
May you please raise your right hand to be sworn? Please solemnly swear affirmative that testimony you shall give shall be the truth, and the truth, and nothing but the truth.
Thank you, ma'am. You can be seated. Ma'am, could you tell me your name and spell your first name for the court reporter, please?
Demorris Hunter, D-apostrophe-A-D-R-R-I-S.
Thank you. Mr. Self, you may inquire.
Thank you, Your Honor. Please, the court. Ms. Hunter, can you tell the ladies and gentlemen of the jury how old you are
25,
and where do you currently live?
Oakland, California.
And how are you related to Demorris Hunter?
That's my father.
And you don't have any memories of your father outside of the times that he's been in jail, correct? And you have a daughter?
Yes.
And how old is she?
She's 6.
And what's her name?
Elaine Marie.
And do you have any recollections of visiting your father when he was in jail in California?
I was like 4 or 5 the last time I seen my father.
Do you continue to have a relationship with him while he's in jail via correspondence or calls or cards?
Yes, letters, phone calls, no visits, but letters and phone calls.
And does your daughter have a relationship with him also that way?
Yes, they told me.
Okay. What does your daughter call Mr. Hunter?
Her grandma.
And that's how you've had to build your relationship through those correspondence and phone calls and birthday cards.
Yes.
Do you love him?
Yes, I
Do you have a relationship with him?
will. Yeah.
Would you like to continue to have a relationship with him?
Yes.
Let me have just a moment.
You may.
No further questions, Your Honor.
Thank you. Cross-examination.
No questions, Your Honor. Thank you, Mr. Attorney.
May this witness be excused? You are free to go, ma'am. Thank you. Defense, do you have any additional witnesses?
No, we do not, Your Honor. That's right.
All right. Ladies and gentlemen, I need to take up some matters outside your presence. I'm going to give you a 15-minute recess at this time. Do not discuss the case among yourselves. Don't discuss it with anyone else. Do not do any independent research while you're away from us. And I will see you back in about 15 minutes.
Madam Chair. Under executive.
You may be seated. Ms. Ferrero, your client does not intend to testify during the Hunter case.
That's correct, Your Honor.
All right, Mr. Hunter, I just need to make sure that you understand that you have the right to testify. I know we've had this conversation before. Can I have you raise your right hand to be sworn, please, sir?
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Thank you. Sir, could you tell me your name? And Mr. Hunter, your attorney has indicated that you do not intend to testify during this penalty phase. Do you understand that you have the absolute right to testify if you wish to do so?
Yes.
And you have the absolute right not to testify if that is what you want? Right. And is it your desire not to testify in this matter?
Can I have a second?
You may. Mr. Hunter, have you had an opportunity to talk to your attorneys about your decision?
Yes.
All right, what is your decision?
I'm gonna pass this up,
So you're not going to testify?
no.
All right, thank you, sir. Let's give the jury the lunch order forms and let them start ordering lunch. Any changes to the jury instructions before I print them?
No, Your Honor.
All
Not
right.
from the defense.
No, Your Honor.
And it would be my intention to just read these straight through after closing arguments rather than before. All right. Then it's going to take them at least 10 minutes to order lunch. So why don't you gather your thoughts for about 10 minutes and we'll come back and begin closing arguments.
Your Honor, before we break, would the court mind inquiring of the defendant? There were several witnesses that have been listed that obviously for strategic reasons the defense has chosen not to call. Would the court mind inquiring of the defendant if he's spoken with his defense counsel about those decisions of not calling those witnesses in the recent agreement?
All right. Mr. Marrero, were there witnesses that were listed that were not ultimately called?
Yes, Your Honor. Most specifically, witnesses in regard to Mr. Hunter's mental health, and we evaluated the testimony of those witnesses and their the potential downsides, what sort of rebuttal could be expected, seeing as some of them were deposed, as well as reviewing the, we, as the court is aware, we had a previous competency hearing for Mr. Hunter about a year and a half ago, at which I was present, and ultimately it was our joint decision as a team that would not be productive, it would not be valuable for Mr. Hunter to proceed with that defense, given several liabilities which I would rather not put on the record.
Gotcha. All right. Mr. Hunter, did you have those discussions with your defense team with regard to calling those witnesses?
I'm discussing it now.
All right. I'll give you a few minutes while I go copy jury instructions, and we'll come back and address it. So we'll be back in 10 minutes. Hunter, have you had an opportunity to have a final discussion with your attorneys with regard to the witnesses that were not called in this case?
Yes.
And are you satisfied with the decisions that have been made with regard to not calling those witnesses?
No, I'm not satisfied, but I understand.
All right, tell me why you're not
I'm not
satisfied.
satisfied by a whole lot of stuff, but we need to move forward.
All right.
We need to move forward.
Do you understand the reasons that the attorneys have strategically decided not to call the witnesses?
Some points,
All right, and do you disagree with other points?
we're going to move forward, so I'm not the whole court process of what's going on in court right now. I know things is not as I perceive them, as I see them. It's realities in front of me right now, but yeah, okay, we're going to move forward.
All right, good enough. Let's,
It's still filling out the.
they're still filling out the lunch order form, so as soon as they're done with that, we will begin with closing arguments, and I believe the state gets one shot, the defense gets one shot, and then I read the instructions.
Yes, Your Honor. That's correct, Your Honor.
All right, thank you.
I just have a question. If I'm going to use the phone number, I'd like to do this.
presenter.
You may be seated. Ladies and gentlemen, the state and the defense have now rested their penalty phase cases. The attorneys will now present their closing arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They're intended to aid you in understanding the case. Mr. Buxton.
Thank you, Your Honor. Please, court, counsel. Ladies and gentlemen, I don't start my closing argument by telling you good morning, because it's never a good morning when the state of Florida has to stand in front of a jury and ask that jury to recommend a sentence of death on a fellow citizen for a crime he committed. But that's exactly what I'm going to be asking you to do. Sometimes people are required to make hard choices, and though the choice is hard, it is the correct one. And that decision and that choice should be made based on the facts and law of the case, the circumstances surrounding the case. The facts and law are what dictate justice. It is those things that make our justice system work, and that's what makes the justice system uniform and not the product of one person's whim or emotion. But rather, justice is the product of a careful analysis of facts and circumstances and how those facts and circumstances fit into the laws that we have all agreed to live by. You heard some people in jury selection say, look, I don't care what the evidence says. Me personally, I cannot vote for the death penalty. And that's okay. I respect those people's honesty and their integrity, because if they hid that information from the parties, this system would not have been fair. This trial would not have been fair. Each of you swore that if you felt the aggravating factors outweighed the mitigating circumstances and you felt the death penalty was appropriate, that you could in fact vote for the death penalty. We are asking you as the state of Florida to do just that, because the facts and the circumstances and the law support the death penalty as the appropriate sentence in this case. The easiest decision might be to go back in the deliberation room after we're all done and say, look, let's just give this guy life and go home. But ask yourself, is that justice based on the facts and circumstances of this case? Is that justice based on what the defendant did to Theresa Green? Is that justice considering that the defendant has already been convicted of another first-degree premeditated murder? As I said, sometimes the right decision is not the easy one. The instructions that the judge is going to read to you in a few minutes, and you've heard very similar instructions when we were doing jury selection, but they're going to give you a detailed process that allows you to go step by step using the evidence, reason, and logic to reach your conclusion. I expect the defense will tell you this several times, and while it is true that your decision as to the proper sentence in this case is an individual determination by each of you, I don't want anybody to think that that means you're not supposed to go back to the deliberation room and actually deliberate. The law requires you to talk and deliberate and discuss the evidence with each other. Our jury system is so wonderful because we bring people from different backgrounds, different upbringings, different lives, different things that you've experienced throughout your life, and we put you together to talk about and resolve important matters. And it is that discussion and that exchange of ideas and opinions and interpretations of the evidence that makes the ultimate decision well-reasoned and well-informed. It's the willingness to listen with an open mind to other people's opinions and interpretations of things that you may not have thought of that makes the decision well-reasoned and well-informed. So I ask that when you go back to the deliberation room, that you discuss the facts and circumstances of the case. Discuss the aggravating factors that you've heard and the mitigating circumstances. Talk about it amongst yourselves. And after each person has had a chance to discuss their opinions and tell each other what you think, only then take a vote and start marking up the verdict forms. That process is what makes the ultimate decision in this case well-reasoned and fully informed. I want to talk to you a little bit about the mitigation that's been presented to you over the past couple days. And much of that testimony is about the defendant's background, his upbringing when he was a young man. Anytime somebody commits a crime or multiple crimes, it not only affects the defendant and the defendant's family, the victim's family, but also those people who knew the defendant. And these witnesses presented by the defense have come in not because of their choice, because of that man's choices. Listening to their testimony over the past several days, it sometimes may become easy to put in the back burner or forget about what really brings us here, and that is the murder, the heinous, atrocious, cruel murder that this man committed on Theresa Green. And that's why we're here. I ask each of you in jury selection to promise me that you would and could meaningfully consider any and all mitigating evidence presented to you. And you all said you would. And I asked you to do that. And I asked you again to go back, discuss the mitigation, talk about it, reflect on it, meaningfully consider it. But I submit to you that when you do that, the mitigating evidence that has been presented to you deserves no weight. The defense's mitigation consists primarily of friends and family members of the defendant, some who have had really no contact or limited contact with the defendant for over 40 years, coming in and telling you when they knew him, the person they knew years ago, he was a good guy. Those people seem like very nice people. There's no question about that. I mean, you heard from Sherman Alexander this morning, 3 foster kids, 2 of his own children, he's doing well in life. And some of those witnesses, especially the Longs yesterday, it was difficult to listen because they became teary-eyed. They became upset because their loved one, no one wants to see their loved one in this position. But again, they are not here because of your choice or their choice. They're here because of Mr. Hunter's choices. Not only his decision to murder Theresa Green, but his decisions that he's made throughout his life to hurt other people as well. Some people that you heard, some of the mitigation witnesses you heard, knew him 40 years ago and had limited conversations with him, limited interactions, if any interaction. When he was over at the Alexander's house as a kid, you heard that he was respectful. He acted right. He followed the rules. So we know he can follow the rules. He can be respectful. He can do what people do if he chooses to do so. Sherman Alexander was raised in the same neighborhood as the defendant. Sherman Alexander has no felony convictions. Sherman Alexander hasn't killed 3 people. Sherman Alexander was raised in a similar household. He said, look, his parents, the defendant's parents, were similar to my parents. Sherman Alexander still supports his friend. He is a true friend, and regardless of what the defendant has done in his past and done in this case, Sherman Alexander still supports him like a friend probably should. Some people said the defendant, when he was young, was nice, was funny, was respectful. I submit to you, ladies and gentlemen, being nice does not mean that a life sentence is appropriate. Being nice when he was a teenager to an elder does not mean that a life sentence is appropriate in this case. I believe one of the Longs said yesterday that he took care of his daughter, that she watched the child when the defendant went and got Pampers. Well, ladies and gentlemen, I submit to you, that's what a parent does. That's what every parent should do and is legally obligated to do. Because the defendant did what a parent should do for his own child does not mean a life sentence in this case is appropriate. It is interesting that I don't think any witness knew about the defendant's prior violent criminal history. They may have known he was in prison and he did something bad, but none of them knew any of the details. The person they may have known 40 years ago is clearly not the man that this man has become. They clearly did not know the true side of the defendant, the violent side, the side that time and time and time again chose to hurt people. They knew the person that the defendant chose to show them. They knew the person that the defendant was as a child. Alfred Costa testified yesterday that the defendant came and lived with him in Houston, lived with his house, and then he moved into Alfred Costa's grandmother's house. Mr. Costa didn't know that the reason he went to Houston was because he was fleeing because he murdered Aurora Huntley in California and then murdered Theresa Green here in Orlando. Mr. Costa did not know that the defendant was a fugitive of justice from 2 murders. The witness's knowledge and impressions of the defendant are at best incomplete. Ask yourself, how much weight do you give their testimony and their opinions and their impressions of the defendant, especially when they're based on their impressions really about 40 years ago, especially when their opinions and their impressions are based on half the story, not the story of the defendant's criminal acts. Simply because there are some people in the defendant's life who, again, based on decade-old impressions, say they love him, does not mean the death penalty is not warranted in this case. Everyone can find somebody in their past to come in and say, when I knew him, he was a great guy, I loved him. That doesn't mean the death penalty is not the appropriate punishment here. The witnesses that have testified didn't know the details of his prior crimes. They didn't know the details about how he killed 2 people before killing Theresa Green and how he hurt 3 others by shooting them. They didn't know about the pain that he has caused other families because of his choices and his decisions. If they did, you think they would have said the same thing about the defendant. You think their impressions may be different. There's no doubt the defendant has people who love him, but it is also clear that the defendant's history of choices that he has made not only hurt his own family members, but also the friends and family members of the people that he has hurt, like the Butlers, like Octavius Hayes, the son of Theresa Green. I stress in jury selection, please go back and consider this mitigation. Please do. After you do it, I submit to you that the mitigation presented by the defense and the opinions of these friends and family members, many of whom are really uninformed about the defendant's true character, should be given no weight at all. I want to shift gears and talk about the aggravating factors that the state has presented. Like we talked about in jury selection, and like the judge will read you, aggravating factors are factors that increase the gravity of the crime or the harm to the victim. They are factors that make this first-degree murder of Theresa Green more egregious than other first-degree murders. The state only has to prove one aggravating factor beyond a reasonable doubt for the death penalty to be an appropriate sentence. Here the state has presented 2. Your first decision is going to be to determine if the state has proven those aggravating factors to you beyond a reasonable doubt. If you find that the state has proven an aggravating factor, that factor then goes on your weighing scales to determine what the proper punishment should be. First aggravating factor the state has presented to you is that the murder of Theresa Green was especially heinous, atrocious, or cruel. And this addresses from the victim's perspective, from Theresa Green's perspective. And notice the word or. Mr. Nunley told you in an opening statement that it is not and. The state doesn't have to prove that the murder was especially heinous, atrocious, and cruel. It's or. So if the state has proven any of those 3 modifiers, then that has been proven. I submit to you the evidence in this case has proven all 3. This aggravating factor, again, focuses on the victim's perspective and how she was feeling, the pain and suffering that she endured before she eventually died. The judge will tell you that heinous means extremely wicked or shockingly wicked. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. Kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless, pitiless, and was unnecessarily torturous to Theresa Green. For this aggravating factor to apply, the state has to prove that the victim at the time that she was being killed was conscious. Because if she was unconscious, she would not be aware of what was happening to her. She wouldn't be experiencing any kind of pain and suffering because she's unconscious. So what evidence do we have to show that Ms. Green was in fact conscious at the time the defendant was murdering her, was strangling her? Obviously, and I expect the defense may point this out, there was no witness who came in here and said, look, I was there, I saw the defendant strangling her, and the victim was aware he was conscious. Why? Because people don't strangle other people in front of witnesses. That's why you have to look at the facts and look at the circumstances about, as far as the case, and the circumstances surrounding how this murder occurred. So how do we know she was conscious at the time she was being strangled? Well, we know from both medical examiners, both Dr. Arden and Dr. Utz. Remember, Dr. Arden was the medical examiner the defense called. Dr. Utz was the medical examiner the state called. Both of them said that in their review of the autopsy documents and records, they saw no evidence whatsoever of any kind of a skull fracture, no evidence of brain trauma, a brain bleed, anything like that. Nothing to indicate or to suggest or that would cause her to fall into unconsciousness like you would if you fractured your skull. The autopsy would have shown that, and there was no evidence of that. So there's no indication or no reason to think that she was not conscious. Her blood alcohol level was about a 0.28. Again, we know from the testimony of the medical examiners that that number is likely artificially inflated. Why? Because she was undergoing decomposition. And during the decomposition process, we know that the bacteria in the body cause fermentation and cause alcohol to be produced. How much? We don't know. That is undetermined. But witnesses said she was impaired. But keep in mind, ladies and gentlemen, when her and the defendant tumbled down those stairs that night in that hallway, testimony of 3 witnesses, Joseph Butler, Joyce Butler, and Lisa Moore, all told you when she got to the bottom of the stairs, she stood up and she walked up that flight of stairs, step by step. No one had said that they had to carry her, or she was so impaired or so out of it they had to pick her up and drag her up the stairs. She walked up there on her own. So ask yourself, how truly impaired was she? And I submit to you that even if she was impaired, when the defendant has his hands wrapped around her neck, that fear, that adrenaline is going to take over. That basic animal instinct of flight or fight is going to take over. She's going to be fully aware of what happened. We also presented to you some physical evidence to show that she was conscious when she walked into that apartment with Demorris Hunter. You heard about the watch that was found. The watch with the defendant's DNA was found on the ground, and Octavius Hayes picked it up and put it in the bathroom counter. But you heard that watch was broken. If she would have walked into that apartment, fallen onto the bed, into unconsciousness, why would that watch be broken? We know that the band wasn't broken when she fell down the stairs because it was still on her wrist and it ended up being in her apartment. No one said they saw her pick up this broken watch, broken inside the house. That is indicative of a struggle. That is indicative of Ms. Green being conscious and being aware during a struggle. We also have evidence of that hole in the wall that Octavius said wasn't there earlier. Again, that is evidence of a confrontation or an altercation inside that apartment after they entered that apartment. If she would have walked into that apartment, fell onto the mattress, fell into unconsciousness, why do we have a hole in the wall? The hole in the wall is because there was an altercation, which shows she was aware and conscious. There could be an argument, maybe she walked in there and she was so drunk she fell into the wall and caused that hole to happen. Well, if that were the case, and that's all that we have, don't you think the defendant would have maybe called 911 or called for help if she was that bad off and fell into the wall? We know that didn't happen. And to believe that happened, you'd have to ignore all of the evidence of the strangulation, the hemorrhage in the highway bill that we've all heard so much about. The evidence on her neck. Which brings me to the physical evidence on her body. The injuries to her neck show that she was conscious during the strangulation process. She was conscious when the defendant had his hands wrapped around her neck and was squeezing the life out of her. Dr. Utz, The defense, I'm sure, will point this out to you as well. Dr. Utt said, look, I can't tell you with any possible doubt whatsoever that those are fingernail marks, but they sure look like fingernail marks to me. And you have to, again, look at the facts and the circumstances surrounding this case to determine what causes those marks. When you do that, the only reasonable interpretation is these marks were caused by fingernails. Look where they are. They're in the exact place where they would be on her neck if he has his hands around her neck, squeezing. Can we tell you, can Dr. Utz tell you, are those fingernail marks from the defendant or from the victim? We don't know. But in either scenario, the presence of those marks and how they appear show that she was conscious and she was aware of what was happening when she was being strangled by that man. They're not just 4 marks in a row, 4 simple marks. If she was unconscious and the defendant decided to then strangle her to death, she's not. If she's conscious, she's not resisting. If she's unconscious, you squeeze, you hold, you squeeze until she's dead. Here, we see chaotic pattern of marks. We see multiple marks in different locations. What does that indicate? It indicates that he is squeezing and releasing and squeezing and releasing and moving his grip around to cause these additional marks. Why? Because she's conscious, because she's aware, and because she's fighting and struggling and thrashing. If they're from the defendant's fingernails, that is why there are so many different marks in different locations, because he's repositioning as she's struggling and squeezing. If these marks were from the victim's fingernails, well, we clearly then, it's obvious that she would be aware and conscious, because what she would be doing is reaching around her neck, trying to fit her fingers between his hands and his fingers around in her neck, to try to pull his hands off of her neck, to try to stop the strangulation from happening. And in that process, she is causing those marks on her own neck. And you saw they're on both sides. She's trying her best to pull his hands away from her neck over and over again until she is no longer able. That's why there are multiple sets of marks like that. So regardless of whether these marks were caused by the defendant's nails or the victim's nails, both scenarios show that the victim, Ms. Green, was aware, was conscious, and was fighting. Fighting to survive. Because we know she was fighting to survive and struggling, we know she was aware, we know she was conscious, we know she was understanding what was happening to her. She was aware that the defendant, her boyfriend, is somebody she supposedly cared about, was wrapping his fingers around her neck, around her throat, and squeezing. That fear would have been unbearable. Second by second, minute by minute, she's looking straight at the face, straight in the eyes of that man as he's putting that pressure and squeezing the life out of her. Eventually, she would start to drift in and out of consciousness, and she would still fight and thrash and struggle. And as she would loosen, the defendant would loosen his grip because she's struggling and fighting. That blood would go back into her brain to cause her to remain conscious and remain aware. Common sense tells you during that process, she would have panicked. As she struggles and manages to loosen his grip, that terror would be starting to set in, and eventually she is going to realize that she is going to die. She struggles until she can't struggle anymore. She can no longer thrash, she can no longer fight. Only then does she thankfully drift into unconsciousness. Only then does her awareness of this horror end. Only then does her pain and does her suffering and does her sheer terror stop. And as the defendant continues to strangle her, only then does she die. Ms. Green wasn't shot in the head. Ms. Green didn't have an immediate death or an instantaneous death. Her pain and her suffering, her mental anguish and her terror was prolonged and it was drawn out. There is no doubt, ladies and gentlemen, that this murder was conscienceless and pitiless. There is no doubt that this murder was unnecessarily torturous to Theresa Green. This murder was heinous, atrocious, and cruel under any set of definitions. Why does this aggravator deserve great weight? Because this aggravator goes to the sanctity of life itself. No human being should have to endure the suffering that Theresa Green did at the hands of that man. This aggravating factor alone outweighs any mitigation that is presented to you. But the state has presented more. The state has also presented a second aggravating factor. That the defendant was previously convicted of another capital felony or of a felony involving the use or threat of violence to another person. Why is this aggravating factor so weighty? First, it shows that the murder of Theresa Green was not an isolated incident. Sometimes people act harshly. Sometimes people use bad judgment, make bad decisions. Sometimes people do things as a result of an isolated incident. When a person has prior convictions for violent crimes, that's not the case. When a person has convictions for felonies that involve the use or threat of violence to another, for felonies that inflict both physical and mental harm upon other people, it becomes obvious that violence is in that person's nature. That's the case with the defendant. Violence is part of who he is. He's demonstrated that for a long time. He's demonstrated that since about 1985, at least, when he was 19 years old. That violence has progressed, as shown by the different convictions that he has acquired over the years, and how the severity of those crimes that he has committed has gotten worse and worse. You heard from Assistant District Attorney John Brohart. You also saw some documents introduced by the state showing the records and the documents of his prior criminal convictions, all from the ones in 1985, as well as the one in 2002, for which John Brohart was the actual trial lawyer that prosecuted the defendant, where he was found guilty of first-degree premeditated murder. The violent crimes that the defendant has committed in his life were not committed all in one day against one person. This is not a situation where he had a one-time lapse of judgment and racked up a bunch of felony convictions in one fell swoop. His violent crimes were committed mostly on different days, in different ways, in different events, and on different victims. You heard from John Brohart, who explained the documents proving the prior convictions, and they are in evidence. I know they're relatively small up there, probably difficult to see, but they are in evidence. And he explained to you the nature of his prior convictions, both from 1985 and regarding the first-degree murder of Laura Huntley that happened in 2002. He explained to you the unique PFN, or personal file number, to make sure that we know that these convictions all relate to that man. And Mr. Brohart, remember, also identified the defendant as the person that he prosecuted for the 2002 murder of Laura Huntley. You also heard from a fingerprint analyst from Orlando Police Department who compared his known prints, the defendant's known prints, to the fingerprints taken of the person who was arrested in California when he was brought back in 2003. They're the same person. So there's no question, I don't expect there to be any dispute, that all these prior convictions that have been introduced are the result of his actions, this defendant's actions. The defendant's decision and choice to begin committing violent crimes began around 1985. And you heard that on January 6th of 1985, the defendant was convicted. This is when the offense happened, but he was later convicted of voluntary manslaughter with a firearm on victim Cesar Guzman. In that same event, on that same day, he was convicted of assault with a firearm with victim Jorge Hernandez because he pointed the gun at Jorge Hernandez with the apparent immediate ability to carry out that threat. Moving on to the next month, in February 4th of 1985, the defendant shot Adolphus Williams with a sawed-off shotgun, and he was eventually convicted of attempted first-degree murder with a firearm causing great bodily harm. 10 days later is when the defendant then shot Eric Wright. He was convicted of attempted first-degree murder with a firearm, again, causing great bodily harm to Eric Wright. And then, March 29th of 2002, the defendant shot and killed Laura Huntley. He was convicted of first-degree premeditated murder, just like the murder of Theresa Green. After he commits the crime against Laura Huntley and murders her, he then flees to Orlando, where he makes contact with Theresa Green and starts up a relationship with her. And now we know why the defendant was using a fake name when he was here. We know why he was going by Mike, because he was running from the police in California because he killed Laura Huntley there. Less than 2 months after murdering Laura Huntley, he comes to Orlando and murders Theresa Green. He then flees to Houston, where he is arrested, and then he is brought to California to answer for the charges regarding Laura Huntley. He is convicted of first-degree premeditated murder there. Then he is brought here to Orlando, Florida, to face the charges that he had here. The defendant has been convicted of not one, not two, but 5 prior felonies. And ultimately, the defendant has killed 3 people and tried to kill 2 others by shooting. When you consider whether the defendant deserves life in prison, when you consider if he deserves leniency or mercy, consider his lifetime of violent criminal behavior and the people that he has hurt and killed. This aggravating factor deserves great weight, and it alone also vastly outweighs any mitigating circumstances that have been presented to you. I submit to you, ladies and gentlemen, when you place the mitigating evidence that is presented to you on a scale, and then you place the aggravating factors on that scale, your scale should tilt far towards the death penalty, because the aggravating factors vastly outweigh any mitigating evidence presented to you. Once you make that determination that the aggravating factors, in fact, do outweigh the mitigating circumstances, the next step in your process, according to the instructions the judge is going to read to you, is to determine what is the proper punishment. I expect the defense will tell you several times that the law never compels or requires you to vote for the death penalty. I told you that in jury selection, that's a given. But what you do know is there are about 9 pages of instructions that you either have been given or are going to be given, and the judge is going to read to you, that will walk you through and guide your decision-making process. After listening to the evidence and determining that there are very weighty and sufficient aggravating factors, and those aggravating factors outweigh the mitigating circumstances, that logical and reasoned moral judgment should be that a life sentence is not warranted in this case. This is an emotional decision, ladies and gentlemen, but I submit to you that the law is most fair, the process is most fair, and the integrity of the judicial system is most fair when your decision is reached based on reason, logic, and a logical method applied in your decision-making process. This decision is a very difficult one, ladies and gentlemen, and it should be. But as I said earlier, sometimes the hard decision is the right one. Each of you in jury selection swore that if you felt the aggravating factors outweighed the mitigating circumstances and you felt the death penalty was appropriate, that you could vote for it. But remember, ladies and gentlemen, the ultimate responsibility in this case sits right there with Mr. Hunter. He is responsible for the choices that he has made in his life. He is responsible for his decision to strangle Theresa Green to death. He is responsible for the decision to commit murder, and he is responsible for causing pain and suffering and death to people in his past. He's responsible for where he sits right now. How many families does the defendant have to destroy before the death penalty is appropriate? How much pain and suffering does the defendant have to cause before the death penalty is appropriate? How many people does he have to kill before we say, enough is enough? Thank you.
Mr. Song.
Ladies and gentlemen of the jury, this is the most solemn phase of any proceeding in our system of justice. You've already carried out your duty determining the guilt of our client in this case. And now the law asks you something even more difficult to do. Decide whether or not to recommend whether a human being should live or die. This is not a decision about what happened, it's a decision about what should happen next. In Florida, the law is clear. Before you can recommend death, the state must prove the aggravating factors are so weighty and so compelling that they outweigh all mitigation, and that death is the appropriate and just punishment. If even one of you, after careful consideration, believes that life is an appropriate sentence, then your voice matters. Your oath matters. Let's talk for just a second about the aggravating factors that Mr. Buxman just talked to you about in closing argument. And we're going to rely on some of the evidence that was talked about in the guilt phase, obviously, in this case. But I'm going to address the second factor, the heinous, or the first one that he talked about, which I think was the second one that they put on evidence about. But with regard to heinous, atrocious, and cruel. We believe that you will be provided jury instructions. So between the two areas that I've marked on this page, I talk about first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of or the suffering of others. Leave this here for just a second while. The state has argued that the killing was heinous, atrocious, or cruel. Those are powerful words. Words meant to evoke something beyond the already terrible reality of a homicide. But not every tragic death meets that legal standard. The law requires something more. The law requires that heinous be extremely wicked or shockingly evil. Atrocious be outrageously wicked or vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even the enjoyment or suffering of others. Well, the state would have you believe the worst possible story. In the guilt phase of this case, you weren't asked to determine whether the factors that went into how this first-degree murder happened. You were presented evidence, and the state has put together their version of the worst possible story. They would have you believe that there was this drunken party and that Mr. Hunter and Miss Green went back into the apartment and had a fight or had a struggle, which is that there's utterly zero evidence with regard to any of that. There's zero evidence with regard to how the hole got into the wall. You may have heard a lawyer argue at one point, I think Mr. Nunnerly may have argued that that may have been a shoulder in some sort of fight or dispute or disagreement with Mr. Hunter. If you look at the height of that hole, the height of that hole is specific to where the bathroom door catch is. And there are photographs that are placed into evidence that suggest that it starts at about 24 inches off of the bottom of the ground and goes to about 36 inches off the ground, which is right about where the door handle catches into the bathroom, which is right about the same level as somebody's bottom or backside, right? It's not the height of the shoulder. Miss Green was 5'5" tall, which is over 60 inches. If you discount the height of her head, which is another foot, then you're talking about, to be shoulder height to be pushed into the wall would have to have been somewhere between 45 inches and 55 inches high up onto the wall. There's no evidence that Theresa Green was ever pushed into that wall. There's no evidence that Mr. Hunter was pushed into that wall. There's no evidence that Mr. Hunter was in the apartment in the first place, with the exception of his DNA on the blood on the watch. Now, what's more likely, using your common sense, did the watch get broken when Theresa Green fell and tumbled down 14 steps from the top to the bottom? Or during some fictitious argument for which there is no evidence that a watch was broken during an argument? It makes no sense. It defies common sense. So this version of stringing together a hole in the wall and a broken watch, there's absolutely no evidence with regard to any of the state's theory about heinous, atrocious, or cruel. You heard or saw the medical examiners, both Dr. Utz and Dr. Arden, testify with regard to the photographs that were shown. Both agree that there is some sort of hematoma or bruise on the back of her neck. Again, what's more likely that hematoma or bruise occurred during a fall and a tumble down 14 steps? They both indicated that they did not believe that had anything to do with strangulation or evidence of strangulation. Once again, there's no evidence of Mr. Hunter's DNA or fingerprints on the body. There's no evidence of Mr. Hunter's DNA underneath Ms. Green's fingernails. There's no evidence of her own DNA underneath her fingernails, meaning that whatever the state's version of the scratch marks, and there were numerous of them, far more than 4 fingers. Does someone have 10 fingers on a hand that would cause that? Or is it more likely that scratching that took place there was a result of a tumble or a fall down 14 stairs over carpet, over concrete, to the bottom landing? Or, as Dr. Arden testified, he believed that was evidence of slippage, the skin slippage, because of the way that the body was placed into the trunk and the pressure, as you see the photographs of her face out of the car, some of the slippage of the skin in that location, that also occurred on that side or that portion of the neck. And Dr. Arden testified that he did not believe that any of the other evidence in the surrounding areas would support evidence of strangulation. Dr. Utz agreed that it could have been from a fabric, could have been from some other abrasion, but it was his ultimate opinion that he believed that there was evidence of strangulation. We don't believe that there's any evidence of heinous, atrocious, and cruel. Going back to Ms. Green's blood alcohol level, it's very important to understand that at a 0.288, there was testimony by Dr. Arden, I believe Dr. Utz may have agreed with this, that the fermentation process that may have taken place doesn't always take place, and they actually have no evidence of it taking place in this case, but that could attribute an additional 0.08 to someone's blood alcohol level. So at a 0.288, we're talking about going to this is math, sorry, but into the tenths, right? The sort of second digit after the decimal place, that 0.08 could have been added. So if you subtracted that out, her blood alcohol still would have been a 0.20, which would have been more than double the legal limit to drive. She clearly was intoxicated. She was clearly intoxicated based on what Mr. Butler testified to. Her drinking, she was drinking Captain Morgan's, and she had been drinking. She drank a whole bottle. Her behavior would suggest that she had been drinking and that she was intoxicated. She slapped Mr. Butler on the way out. She got into an argument. She tumbled down the stairs. All of that is evidence of intoxication. The medical examiners cannot tell you how long it took Ms. Green to die by strangulation. Dr. Utz and Dr. Arden said it could take seconds, it could take minutes. They don't know. And there's no evidence in this case of how long it took her to pass away. We would suggest that there's no evidence that the state has not proved, beyond a reasonable doubt, the evidence of heinous, atrocious, and cruel. all death is sad, and all death is terrible. But all death is not heinous, atrocious, and cruel. In jury selection, we talked about a sort of special subset of all first-degree premeditated murders, right? Killing an innocent person by an individual, not because they're crazy or self-defense or any of those reasons. And there was a reason that we asked you those questions, right? And all of you swore that you could follow the law and follow your oath as jurors, and that you would agree that, as the state mentioned in their closing argument, that if you got the opportunity, or you believe that the aggravating factors outweighed the mitigating factors, and after careful consideration, even knowing that you don't ever have to come back with a verdict in favor of death, that you could. So the possibility that you could do that. You also swore the same to us, or talked about being able to do that as well. So that if the aggravators, even if the aggravators outweighed the mitigators, you still could consider all of the mitigators and give it meaningful consideration, and you still could come back with a life term. So we all stand before you on even footing, asking you to take a look at the actual evidence, not a narrative spun by the state to make Mr. Hunter look like a monster. This is not about trying to demonize an individual so it makes it easier to kill him. This is about looking at the actual evidence in this case and trying to reach a determination about whether or not Ms. Green died in a way that was heinous, atrocious, and cruel. We do not believe that the state has proved that based on all of the actual evidence in this case. Let's talk about the second factor. The second factor was Mr. Hunter's past. These judgments and sentences. And the state argued to you that he's been convicted of 5 prior violent felonies, and that 3 people have been indicted. But he showed you in that 4 of those 5 circumstances all took place in 1985. January and February and March of 1985. Mr. Hunter was 18 years old in Oakland, California at the time all of those incidents took place. By the way, all of those incidents took place with a firearm. Even the later murder in 2002 took place with a firearm. And obviously, in this case, we're not talking about a firearm. There's no similarities, there's no consistency of that. Mr. Hunter's not a monster who goes around shooting people randomly. We don't know what the facts, obviously, of the 1985 case are specifically. We did not hear any evidence from Assistant District Attorney Brewhard that Mr. Hunter was in a gang. He was a gang prosecutor in Alameda County for a long time. He would have provided that information if that were relevant or pertinent. So we don't know what those circumstances are when he was 18 years old and got himself in a series of trouble in those months in 1985. We did hear a little bit more about the circumstances in 2002 involving the friend of his wife that was shot under those circumstances. But I asked you, why are we judging an individual by the worst 4 or 5 days of his life, as opposed to what we tried to attempt to do in the penalty phase, which is to present individuals from Mr. Hunter's past who know him. They know him on the mundane days, the 7th grade days, the 9th grade days, the 10th grade days, the after high school days, when he has a child and a baby in this world. All of those days, if you look at the Alexanders who lived in New Mexico, if you look at his best friend Sherman Alexander, if you look at the Long sisters who he went to school with and how he knew them afterwards. They've known Mr. Hunter for years collectively. And we tried to present a side to him to show you that he's not a monster. The state's trying to say he is. And we're trying to say, but the people that know him best for all of this time, that they're saying he's not. That's not how he is. He cared very much for the Longs and took care of them when he went to school with them. He made sure that they went to school, that they did their homework, that they got lunches when they couldn't afford it. He took care of their mother. He was respectful. He was respectful to the Alexanders. He came over to their house. He rode bikes and mini bikes and dirt bikes and things like that with his friend Sherman. And he was, for all intents and purposes, a normal kid growing up in Oakland, California. And then in the 80s, things get violent in Oakland. Things take a turn for the worse. The state would have you believe that just because Shermer came out of it without a felony conviction, that he's somehow a successful product of Oakland, California. We would argue to you that Sherman had been shot during his youth in Oakland, and maybe that had some impact on what happened in 1985 with Mr. Hunter in terms of the violence that was taking place in California. And maybe that had an impact on him. Remember, at the end of this case, your decision is going to be between a recommendation of life without the possibility of parole and a death sentence. And what we're trying to say is that, according to the law, life without the possibility of parole is a valid decision and a valid sentence that punishes Mr. Hunter for his actions in this case. He's not a monster. He's not a monster that needs to be put down. We don't need to light torches and create pitchforks, sharpen our pitchforks, because the penalty is going to be appropriate either way. But what we're trying to argue is that there is this other side to him, a human side to him, a friend, a person who cared about the people in his life. You also heard from the Butlers and Lisa Moore and even Octavius Hayes that up until this incident, they never witnessed Mr. Hunter ever be violent or aggressive or angry in any way, shape, or form towards Miss Green. So Mr. Hunter isn't. And so when you have to make the decision as to how much weight to give to the aggravators versus the mitigation in this case, I would argue to you that judging a man by his two worst days, and I'm going to lump those 4 events from January to March as one series of events. But basically, we're talking about two days of his life. 4 days if you actually count them individually. But weighing that against a lifetime of being a good friend, a good son, a good father to his child who he's never seen outside the walls of a prison, still maintains a relationship with her, still corresponds with her, corresponds with his granddaughter. So he is here. One of the things you're going to be asked to do after you make your determination about the state's aggravating factors and whether they've been proved beyond a reasonable doubt, again, it's the defense's position that they have not proved heinous, atrocious, or cruel beyond a reasonable doubt, is you're going to then be asked about the mitigators. And the mitigating circumstances in this case that we believe the defense has showed you is that Demorris Hunter grew up in a violent neighborhood in Oakland, California, where he had to learn to protect himself and others. That Demorris Hunter was generous and kind to his friends and family. And that Demorris Hunter was protective of his friends and family and tried to keep them safe and out of trouble. That Demorris Hunter was respectful and obedient to his elders. Demorris Hunter was a loving and attentive father to his daughter, the relationship that they have. Demorris Hunter earned the love and affection of his friends and family who love him still. And the existence of any other factors in the defendant's background not mentioned above that would mitigate the imposition of the death penalty. Remember, mitigating circumstances can be anything we've said or done or emphasized, or anything at all, anything that you've heard that you believe is important. And ultimately, again, the state's going to, as the state talked about in their closing, they're going to ask you to weigh the aggravating factors and the mitigating circumstances. And I would argue to you that the mitigating circumstances, the evidence of his life, right, every day, all of those days, the mundane, even the mundane stuff, who Demorris Hunter really is, clearly outweighs his worst day, the prior convictions. And again, even after this weighing process, regardless of the results of each juror's individual weighing process, even if you conclude the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to recommend that the defendant should be sentenced to death. As we talked about in jury selection, each one of you gets to put on your little robes and make decisions about this case. And all of your decisions individually are important. We talked about how no one would bully someone out of their position, and that others would try to protect people who were being bullied out of that. If one of you believes that life is the appropriate sentence, then that is your decision, and your decision and that decision is perfectly lawful pursuant to these instructions. Respect that moral process, respect your moral decision, respect others' moral decisions, and record that vote. A sentence of life imprisonment is not mercy without consequence. It is accountability. It is punishment. It means he'll spend the rest of his life in a prison cell and he'll never be free again. It protects society. It ensures that he will never harm anyone outside those walls. But it also leaves room for something else. The recognition that human beings are more than their worst thing that they've ever done. I know sometimes in closing arguments I sit here and I think to myself, and I think you'll hear a jury, part of the jury instruction will say that if the lawyers have done anything, that you shouldn't hold it against our client. I heard my voice on the Alexander's video depots from New Mexico, and it drives me crazy whenever I hear my own voice on video. And so if you think that we have said or done something, either Mr. Marrero or myself, please don't hold it against Mr. Hunter, our client. Hold it against me. okay? But as lawyers, obviously, we have jobs to do, and we advocate on behalf of our clients. Sometimes I think I struggle for the right words to say in closing arguments, that I'm trying to be super convincing, the best possible version of myself. But I want to read to you some quotes from others that talk about death penalty cases. And I think it's important to hear perspective of others. Martin Luther King Jr. once said, "Returning hate for hate multiplies hate, adding deeper darkness to the night already devoid of stars."
At this point, can we approach?
You may. The objection sustained.
The state needs 8 votes for death, but the law also requires the power of one conscience, one voice, one juror who says, "I've heard everything, I've weighed everything, and I cannot say death is the appropriate sentence." If you are that juror, if there is any hesitation, any doubt about whether death is just and necessary outcome, then the law does not ask you to set that aside. It asks you to honor it. This is not a decision you can undo. No second chance to reconsider. So I ask you to look at the evidence carefully, to weigh not just the aggravation, but the mitigation, to consider not just the crime, but the person, to recognize that even in the darkest circumstances, the law allows for life. And if after doing that, even one of you believes that the sentence of life is the right sentence, then you must stand by that belief. Because in this moment, your judgment is not just permitted, it is required. Thank you.
Thank you, gentlemen. Ladies and gentlemen, I'm going to begin reading the jury instructions on page 1. Members of the jury, you have heard all of the evidence and the arguments of counsel. It is now your duty to decide whether the defendant should be sentenced to life in prison without the possibility of parole or to death. In making your decision, you must first unanimously determine whether at least one of the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime, and that should be or the harm to the victim. So if you can make that change on page 1. And I'll start that sentence again. An aggravating factor increases the gravity of a crime or the harm to the victim beyond the harm inherent in every first-degree murder. You must not consider any other facts as an aggravating factor other than what has been alleged and proven by the state beyond a reasonable doubt. The aggravating factors alleged by the state are: 1, Demorris Andy Hunter was previously convicted of another capital felony or a felony involving the use or threat of violence to another person. The crime of first-degree murder is a capital felony. The crimes of attempted murder, voluntary manslaughter, and assault with a firearm are felonies involving the use or threat of violence to another person. 2, the first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to, or even enjoyment of, the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Theresa Ann Green. You have heard evidence about the impact of this murder on the family and friends of Theresa Ann Green. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by Theresa Ann Green's death. However, you may not consider this evidence as an aggravating factor. The state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each alleged aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty and your deliberations are complete. If, however, you unanimously find that at least one aggravating factor has been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must consider additional matters to determine whether the appropriate penalty should be life in prison without the possibility of parole or death. First, each of you must determine whether any mitigating circumstances exist. A mitigating circumstance is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not appropriate in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only prove a mitigating circumstance by the greater weight of the evidence, which means evidence that is more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it proven and give that evidence such weight as you determine it should receive. You do not need to reach a unanimous decision about whether the defendant has proven the existence of a mitigating circumstance. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are: A, Demorris Hunter grew up in a violent neighborhood in Oakland, California, where he had to learn to protect himself and others. B, Demorris Hunter was generous and kind to his friends and family. C, Demorris Hunter was protective of his friends and family and tried to keep them safe and out of trouble. D, Demorris Hunter was respectful and obedient to his elders. E, Demorris Hunter was a loving and attentive father to his daughter. F, Demorris Hunter earned the love and affection of his friends and family who love him still. G, the existence of any other factors in the defendant's background not mentioned above that would mitigate against imposition of the death penalty. The final step in the process is for the jury to determine whether the defendant should be sentenced to life in prison without the possibility of parole or to death. In making your decision, you must weigh all of the following factors. 1, whether sufficient aggravating factors exist. And 2, whether the proven aggravating factors outweigh the proven mitigating circumstances. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that to the number and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular aggravating factor or mitigating circumstance. Regardless of the results of each juror's individual weighing process, even if you conclude that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to recommend that the defendant should be sentenced to death. If fewer than 8 jurors vote for the death penalty, the court must sentence the defendant to life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. This recommendation is not binding on the court. However, I am required to assign and give great weight to your recommendation. You will be provided a form to reflect your decisions. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your decisions. When considering aggravating factors and mitigating circumstances, it is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision as to what sentence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, has the witness been offered or received any money, benefit, or preferred treatment to get the witness to testify? 7, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? 8, has the witness been convicted of a felony or misdemeanor involving dishonesty or false statement? The fact that a witness is employed in law enforcement does not mean that their testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe that person to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped. Can I have the attorney's approach, please? Ladies and gentlemen, I'm going to ask that you delete the entire paragraph on the entire first paragraph on page 7. It is inapplicable to this case. I'm going to start reading at the second paragraph on page 7. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The defendant exercised a fundamental right by choosing not to be a witness in this case. You should not be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. These are some general rules that apply to your discussions. You must follow these rules in order to make a lawful decision. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your decision will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Your decision must be based only upon the evidence that you have heard from the testimony of the witnesses, have seen in the form of exhibits and evidence, and these instructions. 3, your decision must not be based upon the fact that you feel sorry for anyone or are angry at anyone. Let me read that again. 3, your decision must not be based upon the fact that you feel sorry for anyone or are angry at anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision. 5, your decision should not be influenced by feelings of prejudice or racial or ethnic bias. Your decisions must be based on the evidence and the law contained in these instructions. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. When you have reached decisions in conformity with these instructions, the appropriate form should be signed and dated by the foreperson. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. And you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of these types of electronic devices into the jury room. And just like last time, the deputies will collect your phones and electronic devices and keep them safe for you when you go to the jury room. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. During this trial, certain items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberation. All of the exhibits will be sent into the jury room with you when you begin to deliberate. And I'm telling you, I'm sending you all of the exhibits, so there will be no other exhibits to send back to the jury room. I cannot participate in your deliberations in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another, or one decision over another. If you need to communicate with me, send a note through the court deputy signed by the foreperson. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. And before I read the last paragraph, I'm going to go over the jury verdict form with you. I think you'll find this to be self-explanatory when you get into the jury room, but it is longer than the jury form that you had last time. At the top of the page is what we call the style of the case, and about a quarter of the way down the page it says jury verdict form penalty phase, and it reads as follows from the top to the bottom. We, the jury, find as follows as to Demorris and D. Hunter in this case. A, aggravating factors. We, the jury, unanimously find the state proved beyond a reasonable doubt that Demorris and D. Hunter has previously been convicted of another capital felony or a felony involving the use or threat of violence to another person. There are two possibilities under that statement. One says yes and the other says no. When you've reached a decision as to that first one, the foreperson would put an X or a check mark on the appropriate line. The next sentence reads, we, the jury, unanimously find that the state has proved beyond a reasonable doubt the existence of the fact that the first-degree murder was especially heinous, atrocious, or cruel. Again, there are two lines underneath that statement. One is yes, the other is no. Once you have reached a decision with regard to that factor, then the foreperson would put an X or a check mark on the appropriate line. The next paragraph reads, if you, the jury, answered no to every aggravating factor listed, Demorris Andy Hunter is not eligible for the death penalty, and he will be sentenced to life in prison without the possibility of parole. If you, the jury, answered yes to any aggravating factor listed, proceed to Section B. Section B, jury recommendation as to the death penalty. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. There's a capitalized, bolded section there. It says check only one. And it reads as follows from the top to the bottom. The top statement reads, we, the jury, have unanimously found the state has proven one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factor is or are sufficient to warrant the death penalty, and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Demorris and D. Hunter should be sentenced to life in prison without the possibility of parole or death. And then there's a line, it says, "We, the jury, find Demorris and D. Hunter should be sentenced to life in prison without the possibility of parole." Then there is another capitalized word, "or," right here, and the second statement is as follows. "We, the jury, have unanimously found the state has proven one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factor or factors is or are sufficient to warrant the death penalty, and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Demorris and D. Hunter should be sentenced to life in prison without the possibility of parole or death. We, the jury, find by a vote of blank to blank that Demorris and D. Hunter should be sentenced to death." Underneath that, it says, "Dated this blank day of April 2026 in Orange County, Florida," and today is the 14th day of April, with a signature line for the foreperson. When all of you have made decisions in this case and the foreperson has filled out the form, the foreperson would knock on the jury room door, let the court deputy know that you've reached a verdict, and the court deputy will assemble all of us together to receive your verdict. In closing, let me remind you that it is important that you follow the law spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Counsel, could you approach, please? Ms. Diotil, you are still our alternate juror, so you will not be going back to the jury room with the other jurors. Did you leave things in there? All right. The court deputy will get a description of those from you in just a moment, and we'll collect those for you. And I'll be back with you in just a moment. For the balance of you, you can take your jury instructions, notepads, and pens. The evidence and verdict form will be sent to you shortly. Your lunch is probably not here yet, but it is? It's on the way. It's on the way. All right, so your lunch will be here shortly. If you have a question, I've already told you how to do this, and I know you know how to do this. You have your foreperson write a note, knock on the jury room door, and the court deputy will assemble all of us together to deal with your question. And with that, I'm going to send the 12 of you to the jury room to begin your deliberations.
Executive.
You may be seated. I really, yeah. And this is what she said, you need it, and I'll take those. Thank you. It's kind of like being a bridesmaid, not a bride. But you did serve an important function as you see you lost a juror early on in this case. Unfortunately, her daughter next year. If you don't want to serve, check the box to serve in the last year and you're automatically. Thank you. And you have my judicial assistant's phone number if you want to find out what happened, what your fellow jurors do in this matter. She's out this week on vacation, but she will be back. Thank you.
She gonna go back to the, or gonna take it back now?
We're going to take a batch now, I'll take a batch.
All right, gentlemen, I'm going to correct the verdict form, and then if y'all could also examine what's going back to make sure only those things that should go back are going back.
Yes, ma'am.
I'm going to just email the verdict forms to you. All right.
So 41 to 45.
All right, I just emailed it. If you can make 3 copies, just take that back. was not given. And it's not part of it. All right, go on with the verdict forms. Yeah, I was. Wait, first. But. All right, then I will see that out. All right, we're gonna adjourn. Thank you. See if that's.
Yes.
Gonna have to have you. I am. It doesn't matter. I just wanted to make sure it. Yeah. But I saw you did the same. All right, is the evidence
Yes.
in proper form, only things that have been admitted are included?
Yes, ma'am.
All right, and we're getting the verdict form. bring him in. Record to reflect that counsel for each party is present, as is the defendant, as he has been voted.
Jury's in order.
You may be seated. Ladies and gentlemen, I understand that you've reached a penalty phase verdict. If you could fold the verdict form over and hand it to the court deputy, please. The verdict is in proper form, and it reads as follows. In the Circuit Court of the 9th Judicial Circuit, and in for 9th Judicial Circuit of the State of Florida, and in for Orange County, State of Florida versus Demorris Andy Hunter, case number 2002 CF 6796. We, the jury, find as follows as to Demorris Andy Hunter in this case. We, the jury, unanimously find the state proved beyond a reasonable doubt that Demorris Andy Hunter has previously been convicted of another capital felony or a felony involving the use or threat of violence to another person. Yes. We, the jury, unanimously find that the state has proved beyond a reasonable doubt the existence of the fact that the first-degree murder was especially heinous, atrocious, or cruel. Yes. We, the jury, have unanimously found the state of Florida has proven one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient to warrant the death penalty, and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Demorris Andy Hunter should be sentenced to life in prison without the possibility of parole or death. We, the jury, find by a vote of 12-0 that Demorris Andy Hunter should be sentenced to death. Dated this 14th day of April 2026 in Orange County, Florida, signed by the foreperson. Ladies and gentlemen, I'm going to ask each of you about the verdict that you have just heard. I'm going to ask that you look at your badge number because I will ask this question by badge number. Do you, badge number 645, agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, I do, Judge.
Thank you. Juror 331, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your
Juror
Honor.
739, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your Honor.
Juror 244, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your Honor.
Juror 341, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your Honor.
Juror 277, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your Honor.
Juror 307, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your Honor.
Juror 414, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your Honor.
Juror 217, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your Honor.
Juror 2203, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your Honor.
Juror 40, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your Honor.
Juror 243, do you agree that the recommendation as read by me accurately reflects the recommended penalty?
Yes, Your Honor.
Thank you. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. And I want to personally extend my thanks to each of you for being here. I know when you showed up for jury duty 2 weeks ago that you did not anticipate that you would be asked to make such a weighty decision. I appreciate your willingness to sit through this process and to come to a conclusion. We will have, before I excuse you, let me see the attorneys up here for just a moment. Ladies and gentlemen, the court deputy will have some work excuses for you. And after you receive your work excuses, you will be free to go. If you receive another summons in the next year and you do not wish to serve, just check the box that you've served in the last year, mail it back in, and you're automatically excused. And I do again want to extend my thanks for you being here. I'm sure that you recognize that we do some very weighty things in this building. We could not do those if we did not have citizens that were willing to participate in the system. I hope you saw that when you came and left the courtroom, we stood. We did that in very small recognition of the very important service that you're paying to each of us by being here. So thank you and have a good day.
Executive.
And he did not get the work excuses. All right. We need to schedule the Spencer hearing. How long do you need to prepare for the Spencer hearing?
Could we pick a date in June, Judge?
Okay. How long do you anticipate it will last?
A day.
A day? Okay. Could do Monday, June 1st.
That works for me. You can see, Rachel.
Yes, Your Honor. We have a Huff hearing on Miller, but I think the AG can handle that. Never going.
Yes, ma'am, that'll work.
That work for you, Mr. Self?
Yes, Your Honor.
All right. Then we will set the Spencer hearing for June 1st at 9 a.m.
Thank you, Your Honor.
And after, I will also want sentencing memoranda from you 30 days after the Spencer hearing.
Okay.
Very good, Your Honor.
Yes, ma'am.
And then I'll set the actual sentencing for about 30 days after that.
Okay.
All right?
Yes, ma'am.
All right. Very well. Then we will be in recess.
Thank you, Judge.
Thank you, Your Honor.